Thank you, everyone. Please be seated. We are here this morning for three arguments. One of them will be submitted without oral argument, and that is State versus Jackson. That is hereby submitted without oral argument. The first case for oral argument is Kirkwood versus Iowa Auditor of State Rob Sand, and it looks like the parties are ready. So, Mr. Ostergren, you may commence.
Thank you, Chief Justice, and may it please the court. I'd like to start by discussing what is referred to in the briefs as the Bellin-McCormley email chain. And you'll recall that we had part of that email chain, but not the complete email chain. The public records request made to the auditor's office was ultimately not answered for 216 days when the full email chain was produced in discovery. 106 days after the petition was filed. Now, the district court ruled that a violation of Chapter 22 was not found because we had not shown that it was an intentional refusal to produce the full email chain, and that the court's statement that a delay in production in the Horsfield Materials case was merely dicta. Now, after this court's decision in Bellin versus Reynolds from earlier this year, it is clear that the district court's analysis is no longer valid. This court made clear that a delay, an unreasonable delay in production of a public record can constitute a violation of Chapter 22. And whether the court's statement about delay in Horsfield Materials was dicta or not is moot. That was the clear holding of this court in Bellin versus Reynolds. And the district court was wrong to graft onto Chapter 22 some sort of intent element. That simply doesn't exist in the law. Intent or neglect could be relevant to ultimately what is the appropriate penalty to be assessed against the government if it refuses to provide a record. But intent is not an element that needs to be shown when pursuing a public records claim. Now, my friend on the other side offers essentially two arguments in opposition to this point.
Just one second. In your petition, you asked for an injunction, and then you asked for a willful violation. Is the request for an injunction mooted?
There's the production of that email chain in full is moot. That portion of our relief is mooted. There are other email chains which have not been produced, of course.
Particular email.
That part, and as the court recognized in Bellin versus Reynolds, once the production belatedly occurs, that specific category of relief is no longer on the table in the case. But what the court also recognized in Bellin versus Reynolds, that you still have a live controversy about the appropriate civil penalty and attorney's fees for having to bring the government into court to make it obey the law. Those are still live controversies for the Bellin-McCormley email chain. And what my friend's brief really glosses over is the court's statement in Bellin versus Reynolds about this very point. My friend claims that our case is mooted completely and cites to the page in the court's opinion in Bellin versus Reynolds where it makes this very point that, of course, we don't need now injunctive relief to have an email produced in full that we already have. That's obviously true. But we still got to go back to district court and decide what's the appropriate penalty to assess against the auditor and, of course, the attorney's fees for our trouble. The other point, which is really not a fair reading of Bellin versus Reynolds that my friend makes in his brief, is the claim that somehow Chapter 22 is bifurcated, that there's an insufficient production claim or a delay claim. And the pin site that's in my friend's brief is simply the court's opinion that describes how the plaintiffs in Bellin versus Reynolds framed their lawsuit. They framed their case as, this is one where there's certain things where there was insufficient production, and there's things where there was delayed production. The court did not, of course it could not, change what Chapter 22 means in Bellin versus Reynolds. It means what it says on the page, and that is the government can be brought into court when it refuses to produce a record. Now, refusal sometimes can be shown by an insufficient production. Sometimes it can be shown by an unreasonable delay. And I suppose that human ingenuity being what it is, there might be other ways that you could violate and show a refusal that I haven't thought of and aren't present in this case. But what the legislature has said is the refusal to produce a record constitutes a violation. And the court has sensibly read into it in the Bellin versus Reynolds case that means an unreasonable delay can constitute a refusal. Now, turning to the other email chains that are in play. There's two statutory exemptions that are offered by the auditor. And I want to talk about the first one because it applies to all the email chains. And then there's another part of the code that's only asserted for one email chain. The one that's offered for the remaining email chains is Iowa Code section 11.42. Now, I think it's important to consider 11.42 in context. It comes right after 11.41, which is a statute that broadly gives the auditor access to the records of all the entities that by law he is charged with the duty to audit. And if that, of course, makes perfect sense. It would be very hard for the auditor to show up at City Hall or at the county supervisor's office or what have you and audit the records of that entity without being allowed to look at all of the papers and all of the computer files and everything else that they look at.
Language, that's a good explanation of the policy, but the language is a little broader. It says information received during the course of an audit. So it doesn't say it has to be information received from the audited agency, right?
That's a fair point, Justice Mansfield. In 11.42, I'm just simply saying I think they should be read in context with each other. They go as a package. But the operative language is in the course of an audit or examination.
I think we need to, you have the disadvantage, you don't have access to these chains, we do. I think, would you agree that maybe the appropriate procedures will review the chains, will review the judgment calls that were made by the court, and if we conclude that some of these things were not received in the course of an actual audit, then you're entitled to them.
And you know, the court has made clear, and perfectly sensibly, you know, we're not entitled just by filing a lawsuit to get everything in discovery. That's the Vaquero case, I believe it's called. That the court, yes, obviously is privy to these emails. I have not seen them. I don't know what's in them. And I am handicapped by the fact that the district court's order respectfully is a bit conclusory in its analysis. It simply says these are subject to 11.42.
On that point, what sort of leeway does a district court get in determining whether something, whether a document was in fact received in the course of an audit? Does the auditor need to bring in a witness to sort of, you know, say to the judge, maybe in an ex parte hearing or something, there is an audit in fact going on about this and here's what's going on? Or can the auditor rely on the statements that it made in the affidavit, I guess, in response to discovery, that simply says this document was received in the course of an ongoing audit. We, in fact, have an ongoing audit going on this subject. Is that enough, or what's the evidentiary standard that the district court needs?
So first of all, Justice McDermott, I would say it's always the government's obligation to show that the exemption applies. So they do have that burden to establish it. And it would depend on the content of the document. I can imagine that there are things that the auditor could receive in the course of an audit or examination that you could tell that's so from their face.
What exactly are you looking for? The statute says information received during the course of an audit. how are you suggesting that it has to be a fairly close nexus and they have to establish that this information actually was used for that audit? Or are you suggesting something less it's the nexus that I'm asking about?
And I want to be clear in my answer. I'm not trying to fight the hypothetical or fight the question. I didn't set out looking for audit and examination papers. I set out looking for communications that the auditor received from a reporter and a blogger, people outside of government.
Back to Justice McDermott's hypo that I didn't mean to interrupt. If the auditor says, we have these audits going on, here are the audit reports, we received this information during the course of this audit, why does that not just end the inquiry?
I can certainly imagine situations where it would be obvious that the document is something received in the course of an audit or examination. If our search terms, for some reason, picked up city payroll records that had people's social security numbers and home addresses and things that obviously the auditor had gathered while doing an audit of the city's books, then the district court would be, I think, very justified saying it's obviously the case. But a communication from somebody outside of government, not an audited entity.
Brings me to the part of the provision that you don't reference in your brief, which is it's not just information, it's information including allegations of misconduct or noncompliance. Wouldn't that be expected, or at least you could see where that might be something outside of government? You wouldn't expect that. That is not limiting language. That's very broad language.
I can't say it would be impossible for that to justify it, but what the court made clear in the Sand versus Doe case, and I think that's an important case because this is a situation where the auditor is sending an information request to a state agency, the regents, for which he clearly has statutory authority to audit. And the court
Investigation that was going on here was not an audit?
So, actually, no, it was not an audit. The special investigation,
Examination. Was it not an examination?
there's an audit or an examination. And an audit is a full-blown, you look at financial records to determine financial condition, and an examination is a subset look at financial records.
So the reports that are referenced in the affidavit that said that we issued a report on these specific dates and that these emails relate to, these communications relate to those reports, those are not audits or examinations within that statute?
Misunderstand your question, Justice Oxley. When you said the special investigation, I interpreted that to mean the auditor's report about Governor Reynolds creating the public service advertisement.
That's where I got that term, I think, from your petition. Is right, we're referencing the same thing.
And so that, I don't think that actually meets the definition of an audit or examination under the code. Audit is defined, examination is actually not. But we don't know exactly what these records are, of course. We didn't set out asking for audit or examination papers. Now, if something that's obviously part of an audit or examination got swept up, then the exception would apply. But what the court held in Sand versus Doe is that the auditor was not conducting an audit or an examination when he makes this query to the regents. Well, if that's true, the auditor initiating a demand for information to a state agency that he has jurisdiction over is not an audit or examination. Him receiving an email from a reporter or a blogger asking whatever, or providing a tip or whatever, cannot, as a question of logic, possibly be within the course of an audit or an examination.
I'm kind of dancing around this, but a very practical problem. You know, in that case, whether or not the auditor's conduct amounted to an audit was at issue. So we kind of had a record about what happened, what transpired, the communications. Here, we just have an assertion by the auditor that this is an audit. You know, I'm looking at this summary of withheld emails, the answers to interrogatories. the auditor says, this information was received during the course of an audit. We issued some reports that may or may not have included information in the emails. Absent testimony about the audit itself, as the auditor defined it, and what happened, how do we make that determination whether or not these were really information related to a bona fide audit or examination? Do we need more discovery? Do we just have to take the auditor's word for it in the posture of this case? How do we resolve that issue?
Answer. Thank you. Your Honor, I think the auditor is, first of all, bound by whatever he told the district court. He has the obligation under Chapter 22 to show that an exemption applies. And if the auditor doesn't make a satisfactory showing in what was presented in the summary judgment record, which is a conclusory statement and a copy of the emails, then I think the court would be, at that point, within its rights, or perhaps forced, to conclude that it's not within 11.42. The auditor, I don't believe that the interplay of Chapter 22 and 11.42 can possibly mean that if the auditor files an affidavit that says, I win, that he wins. That's not the purpose of Chapter 22, which this court has held over and over and over again, is to promote openness in government and transparency. It would be flatly at odds with the auditors simply saying, I get this exemption and I don't have to explain why. So, thank you.
Thank you, Madam Chief Justice, and may it please the court. The auditor must be able to collect and sometimes rely upon tips and information received from people, sometimes outside the government, in dissent.
1142 is not a protection for all tips, right? It's only for a protection for such information if it's received during the course of an audit examination, right?
1142 doesn't necessarily protect all tips.
Let's say, hypothetically, the auditor receives an allegation of misconduct from somebody, and that allegation doesn't lead to an audit or examination. In that case, it's not covered by 1142, or would you agree?
Framework is structured there is, I think you're right, 1142 wouldn't protect the communication if it doesn't result in an audit, but 22.7.18 does. So it remains confidential either way.
Any tip that goes to the auditor, they will withhold under 22.17.18, is that right?
Withholdable under 22.7.18.
Let's say the whistleblower also at the same time sends their communication, you know, puts it out on their social media, sends it to the newspapers and all that. That wouldn't be withholdable in that case, right? Because you wouldn't have a basis for saying that making the communication public would deter the person from coming forward, right?
An individualized communication test. Ripperger says this is an objective test from the perspective of the records custodian, and it asks whether the records custodian could reasonably believe that disclosure of this tip might deter others from making it.
Different from saying that it's not individualized. I mean, in a negligence case, you ask whether the person has acted reasonably or not. It's a reasonableness, subjective reasonableness test, but it's still individualized, right? You still look at that particular situation. Auditor doesn't just get to say everything that comes into my office as a tip I get to withhold, do they?
What is fundamentally different about that is the auditor's statutory duties are to protect taxpayer dollars, to uncover waste, abuse, embezzlement, all these things that
To some extent rely on the purpose of the request, So if the information request is from a reporter, let's say hypothetically, who says, I'm writing a story about this, I want to publish it under my name, can you confirm XYZ facts? Why would that be something that would fall under the protection of whistleblowers? That just doesn't make sense to me.
Well, we're not talking about 70A whistleblowers here specifically, but the reason it's
But I mean, it's the protection of people who wouldn't want their identities revealed. If the nature of the request is, I want to reveal my identity and some information about XYZ program, why would this statute even be implicated?
And it's objectively about whether the auditor could believe that others would be deterred from making any communication, right? So if we get a communication that says, I want to write a story about this, and it's going to be published, and then that's an open record available to anyone, the auditor can reasonably believe there that seeing a communication to the auditor published, even though that person may have, that first person may have wanted to, might dissuade someone else. Wait a second. Am I going to be found out if I submit something in? And so it's a more of a 30,000-foot view here.
Back under the language of the statute a little bit on that. This 22.7.18 says, could reasonably believe that the government body could reasonably believe that those persons would be discouraged. And that's a reference to the extent that the government body receiving those communications from such persons out of the government. So you're saying that's broader, that those persons is not limited to the people that actually provided the communications?
Yeah, such persons and those persons is the category of those persons outside government, right? That's what I'm saying there.
Is it enough for the auditor to simply say, the information relates to an ongoing audit? The audit is relating to the expenditure of COVID-19 funds, period. Is that enough for the district court in looking at an email to say, yeah, I take their word for it that there's an ongoing audit. This relates to some financial issue with state government withheld?
Well, the district court, it was enough because they didn't just have the affidavit. They didn't just have the summary that was provided, that's in discovery, that was filed. Kirkwood has this, which is pretty detailed about here's the date of the email, here's the personnel, here's who they are, here's what's being discussed. And the district court also had, as you do, the benefit of the in-camera review. So it doesn't just have to take the auditor's word for it from this summary. It can compare them against what is in the in-camera records.
How does a district court know that there is in fact an audit going on?
Well, in some of these, this says relates to an ongoing audit. We've done some reports on it. So email number 1, for example, audit reports issued in these dates. So you can go see reports issued on those dates. And then I guess you have to take the auditor's word for it that it is ongoing. But given the history of issuing multiple reports, that seems like a pretty reasonable conclusion.
The 6th, the audit at issue remains in progress. We cannot project an audit completion date. Enough?
Yeah, until an audit report is issued, I think so. Yeah. And look also at what the description is there. References a call, in the call asking to confirm if the auditor issued a subpoena on a certain audit. Audit subpoenas are work papers anyway, and they are filed under seal. And so disclosing the existence of the audit, it violates that confidentiality. And this is important because the confidentiality framework in Chapter 11 is different from the framework in Chapter 22. Chapter 11 is absolute. Chapter 11 is shall be confidential. You're fired if you...
Let's talk about number 6 then, or audit subpoena. Statute protects information obtained during the course of an audit, right, or examination.
Mm-hmm.
So if a reporter emails and says, did you issue a subpoena relating to this audit, why is that information in a work paper related to the audit?
hit on something important, which is the difference between information received and a work paper, right? A work paper is records of the information obtained, conclusions reached, evidence collected, other information collected, right? Black's Law has a pretty good definition of that. And those are crucially important, but we can't collapse the two things. They're both there in 1142. 1142 says information received, including allegations of misconduct, and work papers. But every part of that statute has to do work.
Email to a reporter confirming or denying a fact, a work paper.
This isn't an email to a reporter confirming or denying a fact. This is an internal email among staff in the auditor's office relaying the request from the reporter.
So, Counsel, I'm sorry, you got one?
Their internal deliberation about whether to respond to a request from a reporter is a work paper relating to an audit. That's the argument.
The subpoena itself, generally, and at this time, is confidential. Like disclosing the existence or non-existence of the subpoena and the case and the audit is disrupting the confidentiality expected of work papers.
If the auditor released it to the reporter or confirmed it, what's the implication there? If it's confidential and it can't be confirmed or denied, and they actually did that, how does that implicate the statute?
Matters when, right? It could be, right, that once the auditor finalizes a report and issues a report, the auditor may...
Is releasing confidential information to reporters, are you saying that's protected by the statute?
by the statute.
The fact that the auditor might be releasing confidential information to reporters, is that protected by the statute?
The auditor doesn't. That's why we're here.
We'll see what's in the email, but
You have the email. It's there.
let's just say that the ultimate chain of this is that the auditor is releasing information about an audit to a reporter. They're sending emails discussing that. That wouldn't be protected by the statute, right?
Seems outside the scope of what this case is.
On the point that you were, I think, just kind of getting to about an audit being finished. So the 9th email, it says it's dated March 14, 2019. And then it says, this email constitutes information received in the course of an audit under 11.42. But then number 6 says, the original report was issued in February of 2019. So the email, if I'm looking at these dates correctly, was received a month after the report was issued. How's that during the course of an audit?
Well, it's next steps following issuance of the report, which could be a follow-up report. It could be the audited entity having an opportunity to have a response. And so, yeah, the
thing is, and I think I talked about this a little bit in my concurrence in Sand versus Doe, that it can't be that the auditor just gets to improvise and say after the fact, well, this actually was an audit, this was an audit. An audit has to have, an audit is a defined term, and it has a beginning and an end. And can't we just go through this in good faith and say, this relates, you've demonstrated this was information received in the course of an audit. This wasn't, so Mr. Ostergren gets it.
So the legislature heard you, and the legislature passed a statute this year that defines more rigidly what constitutes the beginning and the end of an audit, right? But that was not a retroactive statute, and a change in the law is intended when, or presumed when the legislature changes the law. So and this time, before this definition was passed and took effect, I think it is fair to read an audit as having broad temporal scope.
Majority opinion, but even that opinion, not everything is an audit.
That's true. That's true. Not everything is an audit.
The auditor have a duty under the Open Records Act, exemption 2218, to contact the requester and ask whether they consent to release of the communication?
That's never been anywhere in the 22-718 case law. There's no affirmative obligation to seek that out. Now, some state agencies, for more routine communications, might even have a form that has a checkbox, right, that says, do you consent to the treatment of this as an open record? And that's all well and good, and that works for some agencies, and they can do that affirmatively, but that's not a requirement of the statute, and it doesn't really work for the auditor's office and duties anyway, because again, the broader 30,000-foot policy here is we want to encourage people to reach out to the auditor, and we don't want perhaps even the like, hey, is it okay if we blast this out to the world? That might be dissuading. Seeing that someone else's complaint has been blasted out to the world might be dissuading, and that's not a good thing, right? We don't want a situation where someone who makes a report to the auditor with genuine concern about misuse of taxpayer dollars is subject to employment retaliation or other things in their job. And so what we need to avoid with 22-718 is the possibility that the auditor gets a report, the auditor gets a complaint, and maybe an angry city attorney calls up and says, hey, who filed that report? I need to know. I pity the fool who crosses me, right? So
Damages, an attorney's fees argument that Mr. Ostergren started with.
what aspect of it?
I think his point is that there aren't separate kinds of claims or counts under the Open Records Act. There's a suit for violation of the Open Records Act, and we said in Bellin versus Reynolds, I think we were characterizing kind of how it was framed by the parties. We weren't saying there were separate suits. So do you disagree at this point still that the case can move forward, at least on the damages claim?
But the district court didn't find a violation. The district court didn't find that there was an unreasonable delay here. So that would not allow for that. I see my time is up. Thank you.
Thank you, Chief Justice. So of course, the district court, yeah, we all agree I lost in the district court. That's why we're here. And this court can find that the auditor violated the law and send it back for an assessment of damages and attorney's fees. Justice Oxley, if you'll forgive me for putting on my readers, I'm going to go back to the point you made on 22-718. And I think, looking at the text, that when it talks about communications not required by law, rule, procedure, or contract that are made by identified persons, they're outside of government, to the extent that the government body receiving those communications from such persons outside of government could reasonably believe that those persons would be discouraged from making them to that government body if they were available for general public examination. It's the same persons textually throughout. It's not, well, if we turn over that John Doe gave us information, even if we have to, that the rest of the world won't want to talk to us, is atextual and I think an extraordinary claim to make that essentially the auditor has taken the position here that he's exempt from Chapter 22, and which raises the question, who audits the auditor? You know, do we have in our law the state that the auditor is just above examination to make sure that he is discharging his duties correctly, to the extraordinary point that to take the position that if there is an email chain with a reporter where the auditor turned over confidential information, if that's what these emails show, to say that that's within the course of an audit or examination and is a protected work paper, then that's a shocking claim. And frankly, although I want to win this case, I hope that didn't happen. Now, on 22-718, it's important to think about how this whole thing cashes out, because there's an obligation for disclosure, then a general exemption, then an exception to the exemption, and then I need a third word for exception and exemption, because there's like an exception to the exemption to the exception, if that makes sense. And the way that whole thing cashes out is, right now, to withhold that information, they have to be able to say that they're going to jeopardize an ongoing investigation or somebody's life is in danger. I assume, I mean, my friend hasn't really developed the, somebody's going to get assassinated for emailing the auditor. I hope we're not talking about that, right? So it all cashes out to, they can't even disclose the immediate facts and circumstances. They can't redact anything that you're going to jeopardize an ongoing investigation. So if those emails show that, then, or that single email chain, excuse me, then the auditor has threaded that needle. But if that email doesn't show that, then of course disclosure is required. And that's of course an ongoing requirement. And if we ever do end up back in the district court, the auditor would have to show anew, or I may renew my records request after argument this morning, because that obligation goes on in perpetuity. Now, my friend, I think, is in a difficult position here because the auditor forces a maximalist position to be taken on what 11.42 means. And I can understand, although I would disagree with, the policy argument that the auditor should be treated differently than almost any other entity in our government and could be completely exempted from all public records law. But that's not what our...
It's the argument. 1142 starts out with notwithstanding Chapter 22. Information received and work papers are to be maintained as confidential. So the legislature has recognized that the auditor has a special position with respect to audits, at least.
No question, 11.42 has meaning, and I don't doubt that. But did the legislature, by saying information received in the course of an auditor examination, functionally mean what my friend essentially said, which is the auditor is not subject to Chapter 22?
With respect to information they receive in an audit, they're not. It starts out saying notwithstanding Chapter 22.
If the auditor...
For me, that's really the issue, is how do we decide whether or not something is within an audit when we've got an affidavit from the auditor that says this information was received. They identify the dates, they identify specific audit reports and audits that are ongoing. So that's kind of where I'm not sure what we do beyond that.
Light is on, may I answer the question? So, Justice Oxley, I think, as what some of your colleagues have suggested, the court is going to look at these emails. And some of you were district court judges in your past lives. You're going to revisit that experience and look at what these emails are and look at what the auditor said and decide, has the auditor threaded the needle to show that 11.42 applies and 22.718 applies with one email chain. And we trust that the court will do that judiciously and fairly. Thank you.
Kirkwood Institute versus Auditor of State is hereby submitted. We will now take a brief pause to let the attorneys prepare for the next hearing.